Good morning to those of you in Australia. Buenas tardes, boa tardes for those in Latin America. My name is Noel Campbell, and I'm the director of the Australian National Centre for Latin American Studies, ANCLAS, here at the Australian National University. Together with the university's First Nations portfolio, let me thank you all for joining us today. This is the third of a series of discussions to consider the approaches of Australia and Latin American countries with significant Indigenous populations to enshrine an Indigenous voice in the political processes of their respective countries. Today, the focus of our discussion will be on the experience of Brazil. But let me begin by acknowledging and celebrating the first Australians on whose land the university operates, and pay our respects to the elders of the Ngambri and Ngunnawal people, past, present, and emergent, whose ancestors have protected and nurtured these lands for tens of thousands of years. Today's program will consist of basically three parts. First, a brief introduction by my colleague Peter Yu, the Vice President of the First Nations portfolio, to give some historical context about Australia's record on Indigenous issues, and in particular, the upcoming referendum to ensure an Indigenous voice in the Australian Constitution. Second, a panel discussion moderated by myself and my colleague, Assistant Professor Tiago Nascimento da Silva, in which we will be joined by three other experts: Leonardo Barros Soares, a professor of political science at the Universidade Federal de Viçosa in Brazil; Priscilla Joaca, the associate professor at the Faculty of Law at the Toronto Metropolitan University in Canada; and Gasparini Caingang, international advisor at the Ministry of Indigenous Peoples in Brasilia. This will be an opportunity for panelists to compare and contrast the approaches of Australia and Brazil to address Indigenous recognition and rights. I should mention at this point a couple of housekeeping matters. Please note that the webinar will be recorded and eventually be made available publicly. For the panel discussion, please feel free to raise questions for the panelists yourselves using the Q&A function at the foot of your screen. If time permits, we'd be happy to draw on them as well. But before passing the floor to the first speaker, let me try to give the subject some context. I think it's fair to ask, what has the upcoming referendum in Australia to establish an Indigenous voice to Parliament got to do with Latin America? Why Latin America? Well, let me tell you why. The United Nations Economic Commission for Latin America and the Caribbean, ANCLAS, estimates there are over 45 million Indigenous people in Latin America. They represent over 50 different ethnic and linguistic groups and comprise some 8.3% of the total population. In many cases, countries with significant Indigenous populations have already reviewed and updated their constitutions to reflect and recognize Indigenous rights. By any measure, then, Latin America is a region which offers a wealth of experiences, both positive and negative, for academics and policymakers in Australia to discuss, to compare, to contrast, and to evaluate those experiences. The first session of this series of seminars, we heard from the former Foreign Minister of Ecuador, Nina Pacari, herself a Quechua woman, about how constitutional reform in that country in 2008 resulted in a fundamental shift in the political paradigm, from a centralized unitary state to a plurinational state, a state that expressly recognizes and protects Indigenous communities, peoples, and nations. The second session considered the case of Chile, where 13% of the population identify as Indigenous. Yet, in common with Australia, they played no part in the formation of the Chilean state. In 2022, a constitutional convention agreed on a new draft constitution, which included several articles recognizing and protecting Indigenous rights. It was put to a referendum in September of 2022, but failed. Not exclusively because of the provisions on Indigenous rights, although in hindsight, they certainly raised concerns that they were too ambitious, too detailed, and insufficiently explained to the public. These experiences were contrasted with a history of First Peoples in Australia, their unique connectedness to country, the injustices wrought by colonial occupation and settlement, their exclusion from discussions about the Australian Constitution in 1901, decades of marginalisation and discrimination, and more recently, a painstakingly gradual path towards reform, culminating in 2017 in the Uluru Statement from the Heart, which called for the establishment of a First Nations voice enshrined in the Constitution, about which we will hear more shortly from Peter Yu. But today we're going to consider the evolution of Indigenous rights in Brazil. Brazil's experience is particularly relevant to Australia, given the commonalities in terms of our size, the fact that we're both former colonies, the devastating effects of settlement on our Indigenous peoples, and the impact of large-scale agricultural, energy, and mining activities on the land and livelihoods of those peoples. Their treatment by colonial and successive governments also has many parallels with Australia. Confrontation, disease, dispossession, displacement, marginalisation, discrimination. But fast forward to 1987. Brazil had recently transitioned from over 20 years of military rule. The economy was in bad shape. Social mobilisation was high, and a 559-member Constituent Assembly was mandated to write a new constitution from scratch. After 2 years of drafting, which included input from 8 thematic commissions, scores of public hearings, and a lengthy process of debate and voting, Brazil's 7th constitution since attaining independence was adopted in 1988 and remains in place to this day. So what did this mean for Brazil's Indigenous peoples? Article 231 of the 1988 Constitution recognizes the social organizations, customs, languages, and traditions of Indigenous peoples. It also refers expressly to their rights to lands they traditionally occupy, and the right to be consulted in the event of proposed use of water resources and mineral wealth by others. And it prohibits the removal of Indigenous groups from their lands. Article 231 also assigns to the federal government the responsibility to delineate Indigenous lands and to protect and ensure respect for all their property. In addition to the guarantees provided by the Constitution under domestic law, protection of Indigenous rights is reinforced by Brazil's ratification in 2002 of the ILO Convention 169 on Indigenous and Tribal Peoples, which is binding on all parties under international law. 37 years later, I wonder what the record has been on Indigenous rights. How effective has the process of land demarcation been? Have Indigenous groups been consulted in the case of proposals for prospecting and extraction in Indigenous lands? Have Indigenous peoples had a voice to legislators on laws and regulations which directly affect them? Has there been progress in reducing the gap between Indigenous and non-Indigenous Brazilians? These are the sorts of questions we hope to explore during the panel discussion. But before we turn to the panel, let me invite Professor Peter Yu, the inaugural Vice President of the First Nations portfolio here at the Australian National University, to give us some context to Australia's record on Indigenous recognition and rights in the lead up to a referendum later this year to enshrine in the Australian Constitution an Aboriginal and Torres Strait Islander voice. Peter is a Yawuru man from Broome in the Kimberley region of northwestern Australia, with over 4 decades of experience in Indigenous development and advocacy. More recently, he's drawn on those advocacy skills as a member of the Referendum Working Group and the Referendum Engagement Group. Peter, the floor is yours.
Thank you very much, Noel, and thank you all for coming and inviting me to participate. I think to start off with, we have something very much fundamental in common, and I think most of you would have seen the announcement that Pope Benedict had made a public apology in respect to the issuing of the papal bulls in the 14th century. With the doctrine of discovery. And so the historical notion of where we find ourselves today, both in Australia, in other colonized countries in the world, had its origins and beginnings, allowing initially, of course, the establishment of the Portuguese and Spanish, the West African trade colonies on West Africa, but also under the colonial justification of the right to invade and conquer on the pretense of bringing Christianity, but also with very racist ideology in respect to the native and primitive nature of First Nations and Indigenous people. So I think that's a historical milestone that we ought to be very conscious that we mutually share, and it's very interesting that that should happen. So I guess that demonstrates more broadly and generally the nature of the transformational position that we find ourselves as communities and societies, whether they be local communities, and challenged by very much the nature of the inherent position and primary position of First Nation peoples with settler states and governments. I think it's a challenge because it's not an easy process to be able to address the nature of the historical legacies and grievances in the way we try to address the more modern contemporary nature of our relationships going forward and all of that it contains. So I've got about 10 minutes, I think, to talk to you, so I'm going to try and be fast. I'm probably going to avoid too much detail, but I'll provide you with some references in relation to some of that detail that you can actually follow up yourselves. So the struggle for rights have always been since when Captain Cook landed in Sydney Cove in 1788, and so I mean that hasn't stopped. So this is shouldn't be seen as something that's constrained to the nature of what's happened in the last decade or decades. This is a struggle for Australia's First Peoples right from the very beginning. Even though some of it is recorded, documented historically, many of it isn't. And I guess you'll note from one of the key commitments under the Uluru Statement from the Heart that a major part of this is the truth-telling, the Makarrata Commission of truth-telling. And I think that's going to be a very challenging but very interesting process in where we go. But needless to say that this has come about of the last decade of engagement, both politically with previous prime ministers. John Howard, way back in the late 90s, made a commitment to constitutional recognition. Subsequent to that, we had Malcolm Turnbull set up the Referendum Council in 2015, I think it was, and then of course we had the Regional Dialogue Convention. So this is a number of senior Aboriginal people under the auspices of the government process to engage and consult widely around Australia with about, I think it was about 12 regional dialogues, which about 12 to 1,500 people participated in those dialogues to arrive at which culminated in the 2017 gathering at Uluru, and then producing the Uluru Statement of the Heart. I was told this morning, and it should be in 1890s and then 1890, the Constitutional Conventions that presented the 1,200 people pro rata provided a larger group of people who were consulted in relation to the Australian Constitution. So I think that in terms of the representation, it was quite significant in that regard. And then, of course, we had culminating in 2021, which was the Tom Calma and Marcia Langton's co-design methodology report provided about the structure for the voice, the proposed recommendations in relation to the structure of the voice. But so we're talking about this very condensed kind of period, but I think it's important to understand this is not something that's just happened in the last 10 years. This has been an ongoing struggle, as I'm sure others would recognise elsewhere around your countries as well too. So basically, the statement, if I have the statement, I just wanted to be able to put up a picture of the statement if you have it there on the screen. You can't read it because it's too small, but we have distributed. Might go on to the next one, next slide. Might go to the next slide, which is the actual, this one here.
Backward.
Okay. So that was the actual, so you might look at it, you can check it up on the web as well too, but we have copies of the actual statement that we've distributed here as well. But fundamentally, the three key things that emerged from that statement was the creation of a voice to Parliament, the Makarrata Commission about truth-telling, and supervise the process of agreement making as well as truth-telling. They're pretty significant. I mean, in 1994, following the Mabo High Court decision, there was also recognising that there was a thing called native title in Australian common law, which was another major milestone in this country. But I think it's important to see that there's been a growing pattern of kind of important legal results that have come down in the favour of Aboriginal people. It's interesting that in 1994, that there was also Prime Minister Keating had a trilogy of response, which is the Title Act, which was setting up a land fund, which is now in the vicinity of about $1.2 billion invested in the Australian Future Fund. And then there was the social justice package. And each occasions, the coalition opposition at those various occasions threatened to basically tear up each of the legislations, the Native Title Act, previous to that, the ANCLAS Act, which was, if you look at the question of the representation and mandate and structure and of the voice, however that is yet to be detailed and designed. We have also similar histories in setting up national representative bodies, going back as far as I think it's 1979, which is the National Aboriginal Consultative Committee, and then 1979 and then 80 was the National Aboriginal Conference. And from there, then you've had the combination of the Department for Aboriginal Affairs and then the Aboriginal Development Commission, as it was then in '89, into ATSIC. So I was an NAC member. I was the youngest elected member of the National Aboriginal Conference for my area in the West Kimberley of Western Australia in 1981. And so you will see, well, why I'm raising this, because it does have relevance in respect to this question of the structure and the mandate and the security and its interrelationship with governments and the broader community. So there have been representative bodies, and those representative bodies have been at various times and occasions, for whatever reasons, have been subject to the political winds of the particular government of the day in terms of their effectiveness and their ability to actually perform what was their duties in respect to representing First Nations people's voices to government in other environments and forums. So this is not something new. This is, again, this is something that's culminated where we are in this time in history in Australia, where we have experience, we have had the structures, but we also see a fairly consistent pattern in the political opposition to the nature of these important initiatives, not just for First Nation communities themselves, but in terms of the reframing of the relationship with the nation state and defining where First Nations people sit in the context of Australia as a modern social democracy. I think that's pretty critically important. So there is form here in terms of the current public debate and argument about the nature of what the voice represents, what is the purpose of it, and what its capacity should be. I just want to give a quick, I think it's important to know that history because we just haven't arrived here today. There are consistent patterns here that tell us about the nature of the ongoing undermining, but I think the ongoing challenges we as Aboriginal face in terms of the systemic nature of racism and the ideological position that continues to underpin and deny us the ability to arrive at a better place than we are at the moment. So the Prime Minister Albanese at the Garma Festival last year in July committed the government, well certainly did on the night of the 21st of May, the election night. The first thing he said on election night was that he's committed to implement the Uluru Statement from the Heart in full. And I think that is quite significant. And so the referendum on this is expected to happen between October and December this year. So the process that Noel has mentioned, I'm on the referendum and engagement working group, which are basically working through the very key issues related to the referendum before it's put to the Australian public to vote on. So it's both groups are comprised of very experienced people representing organisations, their own communities from across the country. The referendum working group was focusing on the wording of the referendum and the timing of it, and the specific proposition in the referendum question itself. And the information, what information needed to be provided and put out there to ensure the voice, to ensure that it was a successful referendum. The engagement group is considering how to build broader community understanding and awareness and support for the referendum. That's a larger group of close to, I don't know, I forget the exact numbers, but I think something like about 60 people are involved in that from communities all around Australia. Then we had the third group, which is a constitutional expert group. Some of the eminent constitutional legal minds in the country that have been providing advice, not to the government, but providing advice to the referendum working group. And the referendum working group, of course, there hasn't always been agreement with the propositions or the position being put by some of the experts. It's a broad cross-section of political background of some of those experts. So as you would anticipate and expect, there are going to be views put that aren't going to be matched necessarily, but to the credit of the working group, we've stuck very much to our position in regards to the advice that we were able to take, but also provide to the government about the final proposition, which has now been put forward. So on the 23rd of March, the government announced the wording for insertion into the Constitution, as well as the referendum question that's going to be put to the Australian public. And then the government introduced a legislation for the constitutional amendment on the 30th of March. So under the kind of processes that we have, the parliamentary processes in terms of here in Australia in respect to addressing such matters. Then they come to the proposed constitutional amendments, which is a new chapter 9, which is called the recognition of Aboriginal and Torres Strait Islander people. I think we've got that here up there for you. So that's the actual proposition that will be going to the Constitution. That there will be a body. Well, first of all, there's the question of the recognition of Aboriginal and Torres Strait Islander people as the first peoples of Australia. So that's the first proposition, is the recognition. And then, of course, there is there shall be a body, the Aboriginal and Torres Strait Islander Voice, that'll make representation in Parliament and the executive governments of the Commonwealth on matters relating to Aboriginal and Torres Strait Islander people. And then the Parliament, subject to the Constitution, has powers to make laws with respect to matters to the Aboriginal and Torres Strait Islander Voice, including its composition, functions, powers, and procedures. Now, you will have heard in the public this whole question about advice to the Parliament and to the executive, to the government, to the executive. There has been various propositions being put about whether or not the Voice should have the capacity to be able to give advice to the executive government. That's been hotly contested issues amongst the more conservative right legal minds, as opposed to others who view that as being insignificant. And some of that advice has also come from ex-High Court judges, Ken Haynes and Robert French, who used to be the president of the High Court, and others have said there's no problem in respect to that ability to provide advice to the executive. And from a personal point of view, from an experience point of view, my working with communities on the ground, as I have for probably most of my career, that has been the biggest challenge and threat in relation to advancement is the question of the relationship with the executive and the ability for us to have some degree of equity and standing status within dealing with, because it is the bureaucracy. It is the bureaucracy that makes the decision or executes the decision of the government. I think this is a very important question because we tend to ignore this. We look at it as from a political lens only, but what we need to look at it is from an operational lens in terms of the capacity to enact the reforms that are required. And I imagine, I don't know what it's like in your country, but I can tell you in this country, we're probably the most governed people in the history of the world. And one of the reasons for the lack of return of the investment that's going towards closing the gap and other benefit issues that are going to, it's a huge burden on Australian taxpayers, and a way of trying to alleviate that is understanding how the intricacies of a very over-dominant bureaucracy operates. I think it's important just to give you a context about the voice idea. But the proposal has been through a significant amount of scrutiny. It's now being debated in the public, of course, and you'll see some outrageous kind of comments from shock jocks and everybody else. But you need to be able to know what the way that misinformation is being spread. So what we have provided, I might introduce at this stage, is a common concern document that we at the First Nation portfolio have been prepared to address some of those concerns that you're seeing out there in the public. We've listed a number of them. There are 12 issues that we've addressed specifically. That is part of the public discussion happening at the moment. And what we're trying to do is basically address each one of them. I'm not going to go into the details of that because I think I'll probably run out of time. But needless to say, this is such a historic occasion. At the moment, the polling indicates that while there is mainstream support still for the referendum, given the level of confusion that's happening out there about these concerns, there is some people who are yet undecided, but 80% of First Nations Australians support the voice, notwithstanding whatever else you hear out there. And they're from the most recent polls that have been taken in the last few weeks. But that document is about the particulars in relation to the common concerns, but also in it are the basic key principles, design principles, in terms of the details that you might have also heard in public being asked, what are the details of the voice? So in there, we'll give you some information. I might stop there. No, thank you.
Many thanks, Peter. I was struck by three particular points that you made, which apply equally to Australia and Brazil in relation to the historical legacy affecting First Nations peoples in our two countries. First, the discredited doctrine of discovery, dating, as you said, from the two papal bills in the 15th century, asserting that Brazil and later Australia were, quote unquote, discovered by Europeans, when in fact they'd been inhabited by the indigenous peoples for tens of thousands of years. The second comment is your observation that the struggle by indigenous peoples in both countries for recognition of their rights has been ongoing ever since. It's not a static process, but rather an ongoing one. And third, your reference to a pattern of developments in the past few decades by which there have been attempts to address the systemic racism and denial of rights. In Australia's case, this has been manifested most recently by the upcoming referendum to amend the Constitution by establishing an Indigenous voice to Parliament. But I suggest that we now move on to the discussion component of today's event. We're going to be joined, as I mentioned earlier, online by Leonardo Barros Soares from the University of Viçosa in Brazil, by Priscilla Joaca from the School of Law at Toronto Metropolitan University in Canada, and Gasparini Caingang, who's the International Advisor at the Ministry of Indigenous Peoples in Brasilia. I guess the most obvious question to raise is how Indigenous identity became an issue at all when the Brazilian Constitution was redrafted in 1987, 1988. But before we go into that, I think we need a little bit of context about the current status of Indigenous people in Brazil. So, Leonardo, perhaps I could ask you to kick off by giving us a brief overview, if you like, of the current status of Indigenous people.
Of course. Well, thank you very much, Noel, for inviting me. And hi, and good morning, and good afternoon, and good evening to our audience. It's such a pleasure to be here. It's very important for me to be participating in the conversation around the constitutional amendment that you guys are trying to do in Australia. And I think that every step towards improving the relationship between First Peoples and states must be celebrated. Well, to provide just a brief overview of the current status of Indigenous peoples in Brazil, I wrote down some figures here. I don't want to miss the point, but I think it's important to understand that the last completed census in Brazil dates back to 2010, and there was supposed to have another one in 2020, but it is not finished yet due to things like the pandemic and other budgetary constraints. They are still trying to finish it this year, but there are already preliminary data regarding the population of Indigenous peoples. So far, they counted 1,652,000 Indigenous persons that identify themselves as Indigenous peoples. That's far more than the previous figure back in 2010, which was around 900,000 people that identify themselves as Indigenous people at the time. That means around 0.5% of the Brazilian population, which shows that the Indigenous peoples are really a tiny fraction of our population. Brazil belongs to a group of countries that, if you take a look at the threshold of like 4% of population that identify themselves as Indigenous peoples, Brazil belongs to this group, which is Paraguay, Argentina, Canada, Australia, and Venezuela and Colombia. And I'm emphasizing that because it has, of course, implications to the way that they mobilize, the way that they organize, the way that they participate in political market, let's put it that way. There are currently in Brazil identified 305 groups, Indigenous groups, speaking around 274 languages. So as I said, we are talking about a group which is very fragmented and scattered across the country, sometimes living in really small communities with 50 people, 100 people, 1,000 people, from the south up to the north. And the majority of them are living in the northern region. There are 7 states composing the northern region of Brazil. If you consider the legal Amazon, then you have to count 2 states more. 9 states, the majority of Indigenous peoples in Brazil live in that region. And the majority of them, around 57%, still lives within Indigenous lands, still live in traditional lands. The rest of them are living in urban areas. But of course, an Indigenous person that lives in urban areas, they have their relatives sometimes in traditional lands. They are able to transit in both worlds, let's put it that way. And regarding the size of the land, recognized as traditionally occupied in Brazil. If you consider all modalities of Indigenous lands in Brazil, I mean, Indigenous reservations, Indigenous lands, or areas that are reserved for indigenous groups that live in voluntary isolation. If you consider all this group of, or all of this kinds of indigenous lands, we are talking about around 13% of the landmass of the territory designated as traditionally occupied by indigenous peoples. Of course, we can discuss later the way that the indigenous lands are demarcated, but the thing that I want to highlight is that it places Brazil in the third place. It's hard to compare data regarding indigenous lands, but if you take a look at the Rights and Resources report, which does this job to compare indigenous lands across the countries, it places Brazil in the third place in terms of size of the area demarcated in the American continent. The first one is Canada, which is a world champion of land demarcation. The second one would be Mexico, and the third one would be Brazil. So that's something counterintuitive. I think that we will discuss a little bit more about it during our discussion here. That's pretty much the nuts and bolts of indigenous peoples in Brazil. The main figures, I think it provides us with a first step to discuss.
Thanks very much, Leonardo. That was certainly informative for we in Australia, who are not always across the detail of what percentage of land is occupied. But let me ask a follow-up question, maybe to direct to you, Gasparini. How do Indigenous Brazilians compare with non-Indigenous Brazilians if we're talking in terms of social and economic indicators, such as health or education or per capita income? Is there a gap between the two populations? Gasparini?
It's a pleasure to be here. I am Gasparini. I'm from the indigenous people Caingangue, is in the south of Brazil. And I am the international advisor from the minister. So my English is not that perfect, but I'm trying to improve them. So thank you for the invitation to speak here in this very important moment for the indigenous people in Australia. This year in Brazil, we had some significant events for us indigenous people, and like the creation of the Ministry of Indigenous People was a great moment for us. But much more than matter of well-being, having our land approved, health and education service, as well as respect for our traditionals, are minimum conditions for our survival. We'll still have a lot to improve, with several cases spread across the indigenous communities, like murders, suicides, sexual abuse of women, and we facing degrading situation such as hunger and invasion of our lands and the contamination of our rivers. So because of this, we are equal in rights, but we still have many cases of discrimination and prejudice in every day in our villages. So we saw this in healthcare, education, and several other points. We saw a lot of this, especially in the COVID moment, but we are trying to improve this. And we are trying to improve this with this minister, because right now we have a voice that be heard for the government. So we are trying to change some things.
Thanks very much, Gasparini. That was really helpful and kind of, I guess, familiar, because many of the same issues face Indigenous peoples in Australia. And there is indeed a gap, if you like, on almost all social and economic indicators between Indigenous Australians and non-Indigenous Australians. I guess connected with that, Gasparini, just while you're still with us, how active are Indigenous people politically? Do they act as a unified entity? Do they have national representative groups that they can use as a channel to convey their concerns and express what their priorities are?
In Brazil, we have a great and a big organization that is called APIB. It's the Articulation of Indigenous People in Brazil. And this organization reunite an organization from all the states in Brazil. So we have this big group that our minister, Sonia Guajajara, was a coordinator until last year. So I was part of this, and we have many other indigenous right now in the minister that was part of this organization. And we also have, we elected a deputy, Célia Chacriabá. So we have a congresswoman right now in Brazil to represent us in Congress. We elect 2 women, Sonia Guajajara and Célia, but Sonia right now is our minister. So we just have Célia in the Congress.
Thank you so much, Gasparini. I think we are all talking about the current situation, but we need to understand how we got here, right? So let's have a clear idea of the historical context. So Priscilla, as in the case of Australia, the colonial legacy in Brazil has had a significantly negative impact on indigenous people, right? Could you elaborate a little bit on the colonial legacy leading up to independence in 1822 in Brazil? How has it affected, for example, indigenous people, such as through diseases, displacement, cultural assimilation through Jesuit missionaries, political marginalization? How did the indigenous group resist colonization? How did it affect the territories they inhabit? Was there any recognition of rights, for example, of indigenous people to their traditional lands? Was there any attempt at a negotiation or treaty process between indigenous groups and the colonial or subsequent Republican governments to establish, for example, a rapport?
Thank you very much for all these questions. Good morning. I'm speaking from Montreal, and here is good evening. So good morning for all of you in Australia, and good evening for Leonardo and Gasparini, who are in Brazil. Thank you very much for this invitation. Very briefly, I'd like to just introduce my positionality. I am a non-Indigenous woman from Ceará, Brazil, the same province of Leonardo. And I am from northeast of Brazil. In the northeast of Brazil, we have the second most large population of indigenous people. So we have APIB as a national organization, and you have APOIM, the articulation of indigenous peoples in Northeast, Minas Gerais, and Espírito Santo. And I am very glad and honored to be here with you all. So it's very good to talk about the northeast of Brazil, because it was in the northeast of Brazil that colonization began. In the north of Brazil, in the Amazon region, the colonization just arrived very, very later on. And what I am going to talk about between the 16th century and 20th century, we need to look more at the northeast of Brazil, including Minas Gerais, and the south and southeast of Brazil, and the Amazon. So talking about the colonial legacy, as Gasparin was saying, I think we have mostly the same kind of colonial legacies, including the impact on health, education, self-determination, political and legal autonomy, the recognition of indigenous people's own rights and laws, the impact of colonial legacy on the bodies of indigenous women and children. And this kind of legacy, I wondered if it is also in Australia. I'm sure that we face this kind of legacy in Canada, where I live nowadays, and sure also in Brazil. However, I'd like to invite you all to think about the resistance of indigenous peoples in Brazil since the beginning of colonization. So in Brazil, in the beginning of the relationship between the Portuguese people and the first peoples in the country that nowadays is called Brazil, but at that time was the traditional territories, the ancestral territories of many indigenous peoples who used to live there and still live and will begin to live. So at that time, the relationship between Portugal and those first peoples began through trading and alliance. However, the practice of Portugal colonization was quickly shifted to a kind of genocide and violent oppressions of indigenous peoples. However, if you look at the point, at the standing point of the recognition of indigenous rights and the recognition of indigenous sovereignty, since the beginning of the colonization, Portugal always recognized the sovereignty of indigenous peoples over their lands. At least if we think about the charters of the king and the decrees. However, in practice, the sovereignty was not respected at all. And this gap between discourse and practice is still practiced in Brazil nowadays, even after the independence of Brazil and even in our current times. So moving on the time, if we arrive almost in the 17th century, the King of Portugal, he in 1648, he establishes a charter that is very important, and it still is important. I'm going to explain why. At that charter, the king recognized that indigenous peoples are the legitimate owners of their traditional lands, and the settlers should respect the lands of indigenous people. So that was the beginning of the theory that you called in constitutional rights in Brazil, the theory of indigenato. That's like the theory that recognizes that indigenous peoples are the original and primary owners of their traditional lands due to their ancestral occupancy. So in 1955, this decree was repeated in some way, and in the first and second constitution of Brazil, the presence of indigenous peoples was not recognized, but anyway, we had this kind of decrees. In the 1822, after the independence, still the Brazilian states recognized the occupancy, the prior occupancy of indigenous people. So why the lands and traditional territories of indigenous peoples were so disrespected and genocides due to territorial conflicts occurred, even though Portugal, and after the first times of the Brazilian state, the territorial rights of indigenous peoples were respected and recognized due to this gap between discourse and practice, and also due to a very complicated practice of the settlers. Actually, two practices. One, it was a violence against indigenous peoples. According to Portugal, they recognize two kinds of groups of indigenous peoples. The ones who were allies, so they should be respected, and the ones who resisted colonization and allied to France and other countries that at that time were trying to compete for the colonization of Brazil. So some settlers, they created artificially conflicts with indigenous peoples to justify the occupancy of their lands and violence against these indigenous peoples. And another practice that were adopted by the Portugal and after by the Brazilian state was deny the existence of indigenous peoples on the lands. So they recognize that indigenous peoples have rights over their lands, but they also affirm that the indigenous peoples were already assimilated and integrated, or they had disappeared. So if there is no indigenous peoples, there are no rights over their traditional lands. And these two kinds of practice arrive after the independence. I know later we will talk about the constitutional framework, so I will stop by now, but I'd like just to tell you that it's very important to know that the theory of indigenato that I told you, that it was created in the time of the colonial relationship and persisted even after the independence that recognized the indigenous peoples as the original and primary owners of their traditional lands, is very, very important, because although even though the whole practice of denial of existence, violence, and genocide against indigenous peoples, the institutional recognition of their traditional rights was and is at the base of the constitutional framework of indigenous peoples' rights in Brazil still nowadays.
Thanks so much, Priscilla. Great overview of the history and how we got the first part of the colonization to the independence of the country. I will follow up with Leonardo, because Priscilla touched on a very important point, Leonardo, that is, on one hand, indigenous people being recognized in their land by colonizers, and on the other hand, the practical consequence of the colonization, right? We could clearly see through the overview that Priscilla gave us that the process was a top-down process in which the colonizers, of course, decide the next move. So this then raised the question about how much voice indigenous peoples had. So did indigenous people have any voice in the process leading up to the independence in 1822, for example? Were the indigenous peoples allies to the supporters of independence? Was there any reference to the existing of indigenous peoples in the first constitution? I think Priscilla also touched that. So thank you, Leonardo.
Yeah, I think Priscilla mentioned it already, the core issue, but just to cover a little bit of what I think about it. I mean, independence process and also the proclamation of the republic, both were political movements carried out by political elites in Brazil. So, which means that there were little political participation, little political popular participation. So, and of course, also little participation of indigenous peoples. Actually, the real role is yet to be known. The extension of the participation of indigenous peoples in the process of independence is yet to be known. We need more research on that. What we do know so far is that indigenous peoples here in Brazil acted pretty much similar to what happened to indigenous peoples in other countries, such as Canada and Argentina and other countries in Latin America, which it was basically that sometimes they had to side with either the Portuguese or the Brasileiros, right? Because the Brasileiros meaning the local elites, the economic elites that grow in the colony, and the Portuguese colonizers. Sometimes they sided with the Portuguese, sometimes they sided with the Portuguese. So this kind of ad hoc alliances happened all the time, and also happened, for instance, just think about the case. We are always referring to Canada because Brazil is very comparable to Canada and also other countries like Australia. And so it's easy to understand. Sometimes during the 18th century, there are a lot of wars in Canada where the indigenous peoples either sided with the French side or with the British side. So it happened pretty much something similar here in Brazil. And regarding the constitution, what is interesting is the first Brazilian constitution, the imperial constitution, dates back from 1824. And there is no mention about indigenous peoples whatsoever in this document. But what I really think is interesting is that the strongman of the independence, actually the guy who is officially recognized as the father of independence, José Bonifácio de Andrade, he wrote extensively about indigenous peoples in Brazil. He thought that the empire, the new Brazilian empire, must have had a kind of political project that would civilize the barbaric Indians of Brazil. But at the end of this process, he was politically defeated, and the constitution doesn't mention indigenous peoples at all. There's no strong legislation during the imperial time that during the imperial era, during the 19th century, that's really focused on the rights of indigenous peoples. Priscilla mentioned this indigenato thesis, which is central to understanding how in a country like Brazil, even in a country like Brazil, where landowners are very powerful, you can still find 13% of the territory designated as traditionally occupied. It's something counterintuitive, right? Because we could probably follow the path of Argentina that waged a war against indigenous peoples, or even Chile. So, but we take another road in terms of indigenous rights during the imperial time and also during the Republican time.
Thanks very much, Leonardo. That was tremendously helpful. I think it's important in order to judge the system today to have a better understanding of what happened before. I might switch the conversation now to the evolution of Indigenous recognition and Indigenous rights since colonial times, and obviously in terms of the key document, the one that actually recognized and guaranteed certain rights for Indigenous peoples, in particular the rights to land that they traditionally occupied, was the 1988 Constitution. But just as a footnote, Gasparini, can I just ask, does that mean that there was nothing that expressly referred to Indigenous people in any of the 6 constitutions between independence and 1988? Was there any reference to Indigenous peoples in any of those 6 constitutions, or was 1988 the first time Indigenous people were formally acknowledged?
In some of these constitutions, we have the right to the land, but in different way that it's not so good that in 88 guaranteed to us.
Okay. I read recently that in an article that referred to the invisibility of Indigenous peoples up until 1988. Is that really a fair assessment, though? Again, I know that there was the creation back in 1910 of the SPI, the Service for the Protection of Indians, and then more recently, FUNAI, the National Foundation for Indigenous People. Can you just explain a little what entities came into being and what they did and whether they were effective in the period between independence and 1988?
Yes. At the beginning of the colonization, Indigenous people were considered soulless. So we need to, the Pope declared that we are really people. To the Brazilians say that we Indigenous people are same people like the others. So just saying this, you can imagine how they treat us. And the SPI was a great, and they are created to protect the Indigenous, but the purpose was more than civilize the Indigenous. They want to try to Indigenous being not that Indigenous that they are, but civilians like the others, Indigenous, the other people in Brazil. So the SPI, it's not so good for the Indigenous. They do some good things, but not in all the contest. And FUNAI, right now, FUNAI, we have many problems because Bolsonaro, the government of Bolsonaro, tried to dismount all the FUNAI. So we don't have any budget. We have less people than we need. So, but FUNAI have the purpose to demarcate the lands. So it's a great organization and foundation that was created to the principal gap that we need, that's demarcate our land. So FUNAI was very important for us, and we are trying to rebuild this foundation right now.
Thanks a lot, Gasparini. That's interesting to know that it wasn't a completely idle period, that Indigenous people weren't entirely invisible, if you like, in that intervening period. Leonardo, maybe I can suggest we fast forward to 1987, 1988, when we had the election of a Constituent Assembly, which was mandated to draft a new constitution, which it did in 1988. Can you tell us very briefly what the highlights were in relation to recognition of Indigenous rights and why in particular Article 231 is a standout article in terms of recognition of Indigenous rights?
Sure. I think it is important to put the Brazilian Constitution in context. The Brazilian Constitution, the 1988 Constitution, can be considered a kind of early example of the new Latin American constitutionalism. And but the first constitution that really stated indigenous rights in the American continent was the patriation of the Canadian Constitution in 1982. And after that, we can place the Brazilian Constitution in 1988. And actually, there are two important articles: the 231 and then the 232. The 231, though, is the list of the basic rights of indigenous peoples. And we could probably summarize that saying that the article basically says that indigenous peoples have the right to be recognized as distinct from the mainstream society. They have the right to be themselves. That's as simple as it gets, but something that took centuries to be recognized. And basically says that they have the right of keeping their traditions alive. They have the right to be taught in their own languages, to have their religious practices protected. And basically says that being indigenous was not a temporary condition, was on the contrary, exactly. Being indigenous is an ontological condition, is an existential condition. And so in terms of land rights, the Article 231 embraces the thesis of indigenato that Priscilla mentioned. And that basically says that, listen, indigenous peoples were already there, so they have to have any sort of control, any sort of recognition of the lands that they traditionally occupy. So this is an originary right to land, which means that this right pre-exists the Brazilian state, pre-exists the Brazilian constitution. And when the government started a land demarcation process, what the state is doing is just recognizing a right that should not be put in question. So that's the crucial or the core of the article, if you like, in my opinion. But I would also like to highlight the Article 232 because it's very, very simple, but very significant, which says that basically that indigenous peoples can represent themselves before courts. That's the formal end of the tutelary regime that was in place in Brazil during the 20th century, because the civil code in Brazil, the previous civil code was drafted in 1916 and put indigenous peoples along with disabled people, children, people with mental health issues, basically saying that they were not people that would use the reason as us Western colonizers, right? So they had to be taken into custody or in sort of tutelage by the state. And so that's the very reason that SPI and FUNAI were built in the spirit of the tutelary regime. And the Article 232 formally ends this policy, saying, listen, they can go before courts, they can hire their own lawyers, they can, just have their voices, they must not have any sort of allowance or permit from the government. They should not ask the government to be represented before courts to push forward their rights, right? So that both articles, I think, that are important to understand.
Thanks a lot, Leonardo. Really interesting to appreciate what a pioneering step it was to draft these two articles of the Brazilian Constitution, and as you say, has served as something of a model for other Latin American constitutions in subsequent years. Priscilla, can I just wind back a little bit to talk a bit about, very briefly, about the process that led up to the draft, or that was involved in the drafting of the Constitution? I mean, who pushed for the language on Indigenous rights? Did Indigenous groups themselves have a voice in the process, or did they have allies or advocates who did so on their behalf? Can you just give us a little bit of an idea about the process that was involved in particular in drafting the language concerning indigenous peoples?
So when our constitution was drafted, it was in the end of the dictatorship regime in Brazil. The dictatorship region in Brazil was between 1964 and 1985. And we need to understand the importance of that constitution, not only regarding indigenous rights, but also regarding the recognition of fundamental rights of minorities, and also the recognition of the most basic fundamental rights for all Brazilian population, including collective rights. So we had, as Leonardo was saying, we were living at a time when the democracy in Brazil was emerging with a lot of force again, and different social movements came together in order to try to influence the process of elaborating and drafting the constitution. They didn't have a direct voice, they couldn't participate directly in this process, but they tried to put a lot of pressure on the Congress people who were there elaborating the constitution. Among the social movements, the movement of the national movement of indigenous peoples in Brazil, we can say, was one of the most important at that time. And it was because of the resistance and organization of indigenous peoples nationally that the Brazilian Constitution recognized not only Article 231 and 232, as Leonardo was saying, but also very important articles that recognize environmental rights, cultural rights, which also protect Afro-descendant communities and local and traditional communities in Brazil. So the indigenous peoples, they were not only able to put pressure to recognize their own rights, but also they help to put pressure to recognize other environmental rights and fundamental rights as well. And in this process, we need to acknowledge the role of no governmental organization, and also of some legal scholars, as Carlos Federico Mares, and some non-indigenous organizations, as an organization that came before the Social and Environmental Institute in Brazil, that's called ISA. So also the CIMI, which was the Council of Mission, of Catholic Mission in Brazil. Sorry, I don't remember how to translate, but we had many non-indigenous organizations also that supported indigenous peoples in order to organize themselves to really be able to influence the constituent process. However, I also think that it's very, very important to remember that at that time, the people who were there testified a moment when indigenous peoples from different regions of Brazil, who were not necessarily allies historically, and all these peoples, they came together, they made a lot of effort to understand more how to create a constitutional framework that could allow indigenous peoples to establish a relationship with the Brazilian state that could really terminate the tutelary regime and the assimilation and integration, the cultural integration that still was responsible for guiding policies in Brazil. So I think we can stop that, but if you have any other questions, I can answer too.
Thanks very much. That was important to put that in context as well, the process, because that's clearly got parallels with a process that we're about to embark on here in Australia concerning establishment of a voice. Just as a footnote, and just a yes or no, was there any pressure, if you like, for Brazil to become party to the ILO Convention, which is also contains important protections of indigenous rights in 2002. Was that the result of any pressure from indigenous groups or other groups, or was that simply a decision that the executive made?
Well, to be honest, I haven't read or heard anything that could that analyze exactly your question, but I do believe that yes, and I'm going to explain why. The ILO Convention on 169 was adopted in 1989, 1 year after our constitution, 1988, when the national social movements of indigenous peoples in Brazil were in their first years as a national organization, because the indigenous peoples in Brazil, they always have practiced resistance to exist, as they say. We resist to continue to exist. So even though the adoption 1 year later and all the social force and political moments that you were living in Brazil, it took many years to the Brazilian state adopt, ratify, and adopt into the domestic law the ILO Convention 169. It was only in 2002. However, when we observe how the discussions went on between 1989 and 2002 regarding the adoption of the Convention 169 in Brazil, we really observe how the indigenous organizations and indigenous national movements, along with their allies and non-indigenous organizations who support their struggle, were there in order to put pressure on the Brazilian state to finally ratify and later integrate into the domestic law this ILO Convention.
Thanks very much. I think we now have a clear idea from all the panelists about the legal framework, which on its face looks very progressive. I think that Thiago is now going to explore a little bit whether there's a gap between the legal framework and principles and implementation and practice.
Thanks so much. Now, thank Priscilla also. So as Leonardo mentioned before, the recognition of certain indigenous rights in Article 231 of the current Brazilian Constitution is an important milestone for indigenous people in the country. However, I think it will be important to understand the practical effectiveness of implementing the Constitution and what lessons we can learn from the Brazilian case for the Australian forthcoming referendum. So I will start with you, Gasparini. So based on the current number of indigenous territories in Brazil as presented by Leonardo in his first answer, how satisfied would you say indigenous groups are with the process of demarcating indigenous lands? Are there still pending claims? What are the main concerns about this process today?
We are not glad at this moment with the policies that we have, because 98% of the indigenous land demarcated is in the Amazon. So all the country have a really big gap in this process. Is a slowly process, and we need to improve them. But we know that we have many fights against the agribusiness and we have companies that interest in this area. So we have many fights to fight to have this gap resolved. And but we need much more indigenous lands in the other parts of Brazil.
Thank you, Gasparini. That's interesting to learn and understand how unequal the process is and all the issues in the current situation. I would add to that, what is the impact of the Bolsonaro's administration policies on this process particularly?
Bolsonaro promised that they will demarcate any land, and they really do this. The government Bolsonaro don't demarcate any land. they actually they have a retrocess in the protection of their lands. We have many more invasions. We have many more deforestations. We have many problems with fires in our indigenous lands. So we have a lot of problems that Bolsonaro government improve. So we face one of the most difficult 4 years that we have in our history.
Thank you so much, Gasparini. I agree with you. There's a lot to do in this particular area. So, Leonardo, I will continue with you, but going back to the process of demarcation of land. So, could you help us understand, for example, what steps an indigenous group need to take, for example, to establish a claim to indigenous land? Who recommends acceptance of the claim? And to whom is this recommendation made? What is the current status of the legal dispute over whether claims should be limited to areas occupied, for example, by indigenous groups at the time of the Constitution's adoption in 1988?
Yeah, historically, the land claims demarcation process in Brazil is a prerogative of the executive power. And after 1988, even before, the FUNAI is still the institution in charge of carrying out land demarcation in Brazil. So there's a decree regulating the whole process, the 1775 from 1996. And I won't go into all the details of the process, but basically it starts with a study of the area. FUNAI sends a team of experts on the ground, lead by a team of anthropologists that try to carry out extensive research on the ground, trying to assess the validity of the claim, to check if the group is really living there and carrying out traditional practices. So a study on the ground can last, I don't know, 2 months, 3 months, even a year, depending on the complexity of the process or the area. And then once the report is drafted, the study is drafted, the team of experts sent to the presidency of FUNAI, which who can either refuse or accept the study. And so after that, if the presidency accepts the study, it sends to the Ministry of Justice, and then the Ministry of Justice declares the area as traditionally occupied. But the whole process finishes with a decree issued by the president. It was already that way during the military dictatorship, and still is the way that the process happens in Brazil nowadays. It's a process that can take a lot of time, as Gasparini was just saying. The average time that a demarcation process takes in Brazil is nothing less than 15 years, which is something incredible to hear. And I recently read an article saying that there was a land in Australia that took, I think it was 30 years to be recognized. It's something like that. And also in Canada, it takes a lot of years. That's something that we should think about. Why do they take so long? So then this is the basics of the process. As I said, I won't go into all the details of the process. The other question that you mentioned, and that's of course linked to the process, is the current status of the legal dispute of what has been called today in Brazilian public sphere the time frame for land demarcation thesis, right? Priscilla, we have been discussing about the indigenato thesis, right? And this thesis was more or less, it went more or less unchallenged during the 20th century in Brazil. In the courts, the judges basically were seeing the process, the disputes, and saying, listen, there's a centuries-old understanding that indigenous should have some right over the land, so maybe it's just what they need, right? So the thing is, after 1988, and especially in the last 20 years, the agribusiness sector started to really collectively organize and put forward a kind of political argument saying that the process cannot be that way, that the land demarcation process cannot be that way. We should establish another process to that. And then they put on the table this argument of what has been called the time frame argument, or the time frame for land demarcation thesis. And they are trying to really establish this new vision of the land demarcation process in a legislative way and also in a judiciary way. If you take a look at the House of Representatives, they recently passed a law with this provision saying that basically the idea is to assess the validity of a claim that a certain indigenous group make over a certain land. To assess the validity, we should be able to prove that they were in the land at the moment when the Constitution was promulgated in October 1988, which is ridiculous because during the 20th century, there were many forced displacements and violence and all sorts of genocides, as Priscilla said, and many indigenous groups that are now claiming the traditionally the occupancy of certain territory, they were not there in 1988, right? So, and before that, they were not even able to fight for their rights before the courts, as I said. So that's something that it's really a threat to indigenous rights nowadays. And there's the same thesis is being judged in a famous judgment here in Brazil, which is still going on. There are 11 judges in Brazil. 3 of them already voted. If I'm not wrong, I think only 3 voted. And so far there are 2-1 in favor of indigenous rights. But we are not able to forecast the outcome of this judgment, to be honest. I mean, that's the political game is still going on, right? So it's hard to say exactly if indigenous rights and indigenous advocates will succeed at the end. So I think I provided some kind of background on the process.
Definitely. Thank you so much, Leonardo, for the clear depiction of the process of the land demarcation, also all the issues. Priscilla, I would like to go back to the text of the Constitution. There's another important principle in Article 231 that is the requirement for indigenous communities to be consulted regarding proposals for the utilization of water resource and mining of mineral wealth or on indigenous lands. A similar obligation is contained in Article 6 of the referred International Labour Organization Convention 169. How has this worked in practice in Brazil? What mechanisms enables indigenous communities to voice their concerns regarding these issues? Have there been instances where a proposal, for example, by agribusiness or mining companies was rejected due to opposition from indigenous groups? And lastly, how do you envision the future of free, prior, informed consent, that in Portuguese we call consentimento livre, prévio e informado?
Thank you for your question. For answering that, I think we need to think first about the beginning of free, prior, informed consent, not only in Brazil, but other countries as well. For example, Canada and many other countries. Actually, it's questionable if the free, prior, informed consent, the FPIC, has really been implemented. We know that it has been recognized internationally and nationally by some countries, but the implementation of this principle is really, really a critical issue regarding indigenous peoples, if we look at international level and also nationally in many countries. So Brazil is not as different. Actually, in Brazil, we are leaving the first steps for implementing consultation, the right to free, prior, and informed consultations. I'm talking about consult, the duty to consult, and now not consent now. This right, it was recognized, as you said, by our constitution, but the most important document in Brazil that has been used to acknowledge, to recognize, and to try to put in practice consultation is the Convention 169. So for many, many years, Indigenous peoples have claimed and have struggled for the implementation of this right. However, until now, we don't have still one example of consultation that was done in Brazil involving agribusiness and extractive industry, especially mining, oil and gas, that really could be considered as meaningful, in good faith, and really free, prior, and informed. We have some examples of consultation that went on in Brazil and that are still going on, and the consultations that are going on, it has raised hope that maybe these consultations could be meaningful ones, but by now we don't have a very good example. However, we have a very good example of practice of Indigenous peoples in Brazil. In 2012, the Brazilian state tried to frame a law for establishing general rules for consultation in Brazil. And many problems went on. And one of the main issues was that the Brazilian state did not consult in a meaningful way the Indigenous peoples and other important actors on this law that was about consultation. So internationally, we call this the consultation on consultation, when the government should consult on the law concerning consultation. So tired of the kind of practice by the Brazilian state that has denied the right to consultation, or that has not implemented well the consultation, and also tried because of the Brazilian state's excuse, saying that the consultation was not being implemented in the country because there were not rules and norms and procedures for doing so. The Indigenous peoples in Brazil, they began to elaborate their own consultation and consent protocols. The first Indigenous people to do that was the YMP in 2014. We have an example of consultation that is going on still regarding the YMP Indigenous people. We have other examples, one of them involving a Canadian mining company regarding the Jurunan and other Indigenous peoples. So since 2014, almost on a little bit more than 70 Indigenous peoples, Quilombola and traditional communities that have already elaborated their own protocols. So if you think finally, again, about your last question about the future of FPIC in Brazil, I think we need to look more deeply and with a very good sense of observation of how these protocols will be implemented. These protocols, they were already recognized by the Brazilian state and recognized by the Brazilian judiciary, the judicial system, due to the recognition of Article 6 of Convention 169 that recognized that Indigenous people should be consulted according to their own their own political institutions. So these protocols were recognized, but they are still being implemented. And I really believe my thesis was about the Indigenous consultation and consent protocols. So I really believe that if we have some hope in implementing really and effectively and fully FPIC, not only in Brazil, but in other countries as well, we need to begin to respect these protocols, to really make place and make room for their fully implementation, and begin to think about FPIC not only as a result, but as a process that are built on with Indigenous peoples. And through this process, Indigenous peoples should have a voice, not only in the result of the consent, but also how the consultation and the consent will be proceeded. So I think this is our hope in Brazil right now regarding FPIC.
Thanks very much, Priscilla. I'm very conscious that we're already over time, but I desperately want to leave a couple of minutes for the last question that I was going to ask. Thanks for your explanation in relation to free, prior, informed consent. Of course, that's an issue, as you say, that involves many other countries, including Australia as well. Suffice to say, it is very much a work in progress. It is really interesting to see that Indigenous peoples themselves are looking at ways to develop protocols on how to achieve free, informed and prior consent. I will now go to the last question that Thiago and I were going to ask, which is about prospects for the future. And maybe if I could ask each of you to respond to an element of this question. Gasparini, let me start with you. Has the constitutional reform back in 1988 improved the status of Indigenous people, would you say? If not, what would you say are the top 2 or 3 priorities for Indigenous people right now?
This it clearly improves a little bit the Indigenous situation, because we start to be seen and to be heard, but it's not before this constitution. We cannot go out of our village if you don't ask permission to the government to go to the village, another village. So because of this constitution really improved our life. And right now our main struggle continues to be the demarcation of our territories, because the fight for the Mother Earth is the mother of all our fights. Because without our land, we don't have health, education, we don't have our culture, we don't have nothing. So
excellent. No, thanks very much for that. Leonardo, it's all very well to aspire to improvement and to aspire to full implementation of the rights contained in the Constitution. But what would you say are the main challenges to more progressive policies to support Indigenous peoples? Is it a hostile Congress? Is it the pending decision of the Supreme Court on the question of the time frame? Is it the lack of an effective channel, if you like, to convey the views of Indigenous people? Is it the federal system? Can you just give us a very brief and in 2 minutes impression, if you like, of what the main challenges to more progressive policies would be?
Yeah, I agree with the points that you just mentioned. I mean, the hostile Congress definitely is the main veto point for Indigenous rights today. There's a hostile caucus of conservative congressmen that are very radicalized in the ideological terms, that are really blocking and strongly opposing the Lula's government. So we might have to take a look on that. If the decision of the Supreme Court is negative to Indigenous rights, it would be simply a disaster. That's the easiest way to describe. And also the lack of an effective medium, as you said, to convey the Indigenous voice through the parliament. And because Indigenous peoples in Brazil are competing in the political market without any special kind of support, right? They are competing pretty much like other social groups. So it's hard for them to make bigger caucuses in the Congress. So that's one of the things that I think is interesting in the case of the Australian experience, which is the idea that's a kind of to build an institutional device to really put forward Indigenous voice through the parliament. So that would be the 3 main points really that we could consider that are blocking, or they are threats to more progressive Indigenous policy in Brazil.
Thanks for that, Leonardo. Priscilla, let me let you have the last word then. Given the challenges that Leonardo has just touched on, I'm still unsure about whether to be optimistic or pessimistic in relation to the future in Brazil. I mean, there's a new government, right, that is committed to improving conditions for Indigenous peoples. There's a new Ministry of Indigenous Peoples that has been set up and a new minister. But does the minister and the ministry and the president actually have the power and the resources to make progress in the light of the challenges that Congress and perhaps the Supreme Court would face? I mean, are you optimistic about the future in relation to progress on Indigenous rights under the new administration? Easy question, no?
Yeah. Yeah, wow. I have 1 minute. So I'm going to answer as a legal scholar, it depends. It's not yes or no, being optimistic or pessimistic. I think it's more about being critically conscious of the colonial legacy that is still going on in Brazil, the totalitarian regime that indigenous peoples still have to face in Brazil. For example, we have an Indian Act in Brazil that is still in force, and it's almost unconstitutional because it's against many constitutional principles in Brazil, and it's still in force. We have some kinds of practice by the Brazilian state, independent of the government, that affect deeply the bodies of indigenous women and children and their territories and environment where they live. And it is independent of the Brazilian government, as part of the systemic structure of the Brazilian state that needs to change. At the same time, we are living in a very particular historical moment in Brazil, I think. Personally, I am impressed. I really hope that we can continue to make room for the indigenous participation. I'm not saying that we indigenous need to make room for that. I'm not saying that. I'm saying the Brazilian society and the international organizations and all states should more and more make space and make room for the indigenous participation. And as Leonardo was saying, we are looking forward to seeing how the Australian experience will go on, because I think we can also learn from that experience. And finally, if we have hope in Brazil, we have hope in the indigenous peoples who were there, and Gasparini and Sonia Guajajara and many other amazing and wonderful and fantastic indigenous scholars and indigenous activists and indigenous lawyers who are more and more occupying in a good way the institutions in Brazil, and who are able to intertwine their local activities with their national and institutional activities with international struggles. So I think the indigenous peoples in Brazil, they are leading the way, and this is where we need to put our hope and force, and to critically think of how we could more and more change the institutional Brazilian state and framework that is violent against indigenous peoples, and how we non-indigenous people can more and more support the indigenous peoples who are leading the way through this whole change and struggles that they have been doing centuries in Brazil and other countries as well.
Thanks very much, Priscilla. I am going to have to end the webinar, regrettably now. I think we've covered a tremendous amount of territory in, well, almost 2 hours. Thank you very much for your forbearance. But judging by the number of people who remained as participants, there was clearly a very high level of interest in what you had to say. I think that clearly there is advantage in sharing experiences because they're common problems. We often in Australia tend to look at nearby countries or English-speaking countries as the model for discussing options for dealing with issues such as Indigenous issues, without realizing, as I said right at the beginning, that, hey, Latin America has 45 million Indigenous people. Maybe we can learn something from a conversation with them as well, and vice versa. So I am very conscious of the tremendous challenges that each of you have talked about. Equally, in Australia, we face a very dark history and many challenges looking ahead. In both our countries, I think we are at a critical moment. We're kind of optimistic, aren't we? but the challenges are very great. In the case of Australia, the question is, well, what if the referendum is not successful? That is going to will that take the conversation backwards? In the case of Brazil, if there cannot be a resolution of the demarcation of land process, if there cannot be progress on the question of free and informed and prior consent, is that going to take the lot of Indigenous people backwards? I'm on the optimistic side of the calendar. I believe that, as you say, Priscilla, there's a degree of momentum, if you like, both domestically and internationally, that will eventually, in my view, ensure that we do see progress to the benefit of all peoples. So let me just conclude by thanking all of you immensely, to Peter Yu, who gave the introduction, to Leonardo Barros, to Priscilla Joaca, to Gasparini Kaingang. Thanks for providing the perspective from the Brazilian experience of achieving constitutional recognition for Indigenous people. Thanks to my co-moderator, Thiago Nascimento da Silva, and thanks to the support staff from the ANU College of Arts and Social Sciences. I hope that all of you participating will consider joining us again next month, when we hope to have the fourth in the series of looking at the experiences of Latin American countries in dealing with Indigenous issues. So thanks again to all of you, and enjoy the rest of your day.